Hey everyone, I'm here at the AILA 2023 conference in Orlando, Florida. It is the biggest immigration conference in the United States, and there's going to be hundreds of immigration attorneys from all over the country, and also agencies such as USCIS and Department of State and ICE. We'll be speaking and covering many topics, and I'll also be speaking as a panelist on one of the emerging topics, which is Mandamus. Stay tuned for more. So just got done with the Department of State Open Forum here at AILA 2023 and wanted to share some insights with you. Essentially, the Department of State at the consular level deals with a lot of issues. One of the issues that oftentimes comes up is the issue of immigrant intent when an applicant files for a non-immigrant visa. In those situations, it is a burden on the applicant to show that they do not have an immigrant intent and that they will return to their home country after the completion of the purpose for their visas. Oftentimes, the Department of State will deny visa applications for immigrant intent under INA 214B. In these situations, the takeaway is that it's imperative for applicants to support their application, especially at the interview stage, with evidence showing that they do intend to return back to their home countries. This can include any sort of documentation that may prove this. So it could be things like job offers, property ownership, bank statements, where your family members reside, things like this. This will go a long way to avoiding this denial under INA 214B. Maybe not ensure it, but since the burden is on the applicant, the representative from the Department of State made it clear that this is what they're particularly looking for in these situations and why it's important that you provide this information. So one of the topics that we covered today on the first day of AILA 2023 has been adjustment of status and how to get prepared for your adjustment of status interview. One of the important things that I took away from this has been the importance of knowing what exactly is in your immigration file. And in particular, when possible, ordering a copy of your file by filing a Freedom of Information Act request. By doing so, you'll be able to see what information the government may have that they're able to disclose to you that's currently in your immigration file that you may or may not know about. Another important thing that was highlighted was the importance of the differences in adjustment of status applications when they are before the immigration court or when they are before USCIS. Of course, when you're before USCIS, your adjustment of status application is going to be adjudicated by an officer and not an immigration judge. And it's less adversarial than when it is before an immigration court, where the immigration judge, who's a neutral arbitrator, is going to be making the decision, but the Department of Homeland Security is going to be represented by an attorney on the other side. Those two are very different. Of course, they're both adjustment of status applications, but they are very different. And it's important to know the differences in both of those. So especially important to consult with an attorney who knows the differences in both.
So I want to talk to you today briefly about Board of Immigration Appeals and the things that we learned about at AILA 2023. Today, there was an open forum by EOIR, which consists of the Immigration Court and the Board of Immigration Appeals. So in my previous role as a trial attorney for the Department of Homeland Security and as an assistant U.S. attorney for the District of New Jersey, I've had a lot of experience with Board of Immigration Appeals. However, it is sometimes difficult to know what is actually going on behind the scenes, especially at their clerk's office, and how they organize cases, when you can expect a case decision to be made, and just generally how the behind the scenes looks at the BIA. So what we learned today is that the BIA clerk's office has about 9 production units, and they're divided into non-detained and detained cases. So If you are a detained individual and you file a Board of Immigration Appeals, according to the BIA, that case is going to be expedited by their production unit and assigned quickly to a Board of Immigration judge. And that case is kind of put on a fast track as compared to non-detained cases, meaning cases filed by individuals who are not in immigration detention. The Board of Immigration Appeals also clarified that their cases are adjudicated on a first in, first out basis, with the exception of joint motions or any sort of joint motions, actually. So that means any sort of motion filed by Department of Homeland Security and the respondent jointly seeking something is going to be expedited and not necessarily done on a first in, first out basis. That means maybe a joint motion to remand back to the immigration judge or a joint motion for some sort of relief.